To welcome everyone to the fifth meeting of the 2021 Social Security Committee. No apologies have been received. I think probably the technical hitch there was that Bob's running late, so perhaps broadcasting wasn't aware that I was going to chair until Bob can get here, so apologies for that. We go to item 1, decision to take item in private. The committee is asked to agree that item 3 on today's agenda, consideration of evidence heard today and future consideration of the draft legacy and annual report, is taken in private, and I will assume that everyone has agreed to that unless you indicate in the chat box. Since no one has, I'll indicate that I'll take that as an indication that that is agreement. Thank you. So we move on to agenda item 2, child disability payment. So this morning we will be taking evidence on the draft child disability payment regulations from members of the Scottish Campaign on Rights to Social Security. So I would like to welcome to the committee Bill Scott, known to probably all the members, Senior Policy Advisor at Inclusion Scotland, Anne Baldock, Financial Inclusion Programme Coordinator, One Parent Family Scotland, and Ed Pybus, Welfare Rights Officer of Child Poverty Action Group in Scotland. As usual, ask members to keep their questions succinct. I have a number of members who have indicated that they do want to ask on specific themes, but obviously if you'd indicate in the chat box if there's a specific theme you'd like to ask a question on. I don't have any indication in my notes that there's an opening statement. Is that correct? We're just going straight to questions. Okay, thank you very much. So, are you going to make an opening statement, Bill?
No.
Sorry.
No, I was going to make it.
In that case, we will go to theme 1, and I'd like to call Alison Johnson.
Thank you, Deputy Convener, and good morning to everyone. Can I ask in the first instance how the organisations represented by SCORS were involved in the development of the regulations? Who'd like to kick off? Bill?
We've been involved in a number of ways in the development of the regulations. Myself and Ed, for example, are members of the expert group on carers and disability benefits, which gives advice to the Cabinet Secretary. Now, that isn't as SCORS members, that's as individuals, but they were involved at an early stage in the development of the regulations. SCORS were also consulted directly by officials and the Cabinet Secretary on some of the proposals for draft regulations, and then we were all, as individual organisations, able to respond to the call put out by the Social Security Commission to give comment on the draft regulations, and in each of those instances, I think that it would be fair to say that we got a good hearing, and there have been changes made at every stage in line with some of the suggestions that were made by the various groups and organisations. So we're very pleased to see some of the amendments to the draft regulations that have been made prior to them coming before the committee today. Ed or Anne, do you want to add anything?
Do you want to go, Anne?
Yeah, just to sort of confirm what Bill said, that OPFS definitely feels that we were involved quite heavily, and we were consulted on from the start of the regulations right the way through. Our organisation have also been involved with organising users groups, and some of our parents have taken part in one-to-one consultations with the Scottish Government, and actually have been involved in the testing of the forms. So we've been quite heavily involved in it, and we're really pleased that there has been so much involvement from organisations like ourselves.
Can I maybe, before Ed answers, if he might have a comment, because I noticed that Bill said that you've had a good hearing and the Scottish Government says that they've been listening carefully to feedback, but the SCOR's submission certainly notes a few outstanding issues where there's obviously a view that more needs to be done on a raft of issues. I just wondered if Ed might like to comment on that.
Ed?
Sure, yeah. So, yeah, I think I'll firstly echo what Bill and Anne have said in that SCOR SAMA members have been consulted throughout this process, and we've seen a large number of our recommendations taken up as the regulations have been drafted. But there are a few outstanding issues. I think there's two sections, I guess, some on policy where we maybe diverge slightly with what the Scottish Government's policy is. I mean, some on some technical aspects of the regulations where we feel that they maybe don't quite reflect what the policy is, and the Scottish Government maybe have a slightly different view on that. So I think they're kind of split into two areas, and I guess we'll touch on some of those areas later on. I guess the SCOR's accepted quite early on the broad policy decision of a safe and secure transition, so we've all been working towards making sure the regulations for Scottish child disability payment reflect the entitlement conditions for disability living allowance for children, and look to make revisions to the rules later on after we've had this safe and secure transition. I don't know if you want to go into some of the sort of specifics of where we feel the regulations don't quite match up at the moment, or if that will come with some of the later questions.
Yeah, that will come with some later questions. Alison?
Yeah. Can I just ask, on that safe and secure transition, the briefing that we have from the Parliament's Information Centre notes that might limit the scope for change. Do you feel that within those constraints, the Scottish Government has done all it can to ensure that the child disability payment is an improvement on child DLA?
I'm happy to come in there.
Yeah.
Bill Scott?
Go ahead. No, Ed, you want.
Sorry, is it me or Bill? Yeah, sorry. So yeah, I think many of the areas where we hope to see improvements in the processes rather than in the regulations. So there's a lot of policy intent there to ensure that the assessment process is far easier for families with a disabled child, and that decisions are made more quickly, that awards are made for a suitable length of time rather than the shorter awards we're starting to see with DLA. So where there is intention for there to be a lot of improvement is within the processes, which probably aren't covered by the regulations as such. So it'll kind of be a case of having to wait and see if those processes, if that happens when the processes are rolled out.
And could I ask a final question to Bill Scott, if I may? Do you believe there are any lessons from the policy development for the child disability payment that should be applied to the development of future payments, especially the adult disability payment?
Yes, very definitely. As I say, I think Scottish Government have done a lot to seek the views of practitioners, and Ed's more of a practitioner than I am, because he and as is Anne, in terms of providing advice directly to people or providing advice to advisors. But both at a policy level, people like myself, our views have been sought, and sometimes that's involved one-to-one conversations with officials. Initially, just setting out their thoughts and seeking views, and I think that is a really good starting point before you better off to put things down in paper, to just run things by people and say, we're thinking of this, what do you think? And making a very good, it's really right from the very outset, trying to make sure that what you're planning to do is in line with the needs of the users of the system. And again, in terms of my own views, they're set by our members. So we consulted with them throughout this process as well. People do feel they've been heard, and I think that's a really important thing in terms of dignity and respect. If people feel that they've had an opportunity to air their views and genuinely be heard by the person listening, rather than telling them what's going to happen, then that's important. And no, we've not got everything we've asked for, and we will still be seeking a few more changes. But there are a number of significant changes there, which I think will improve things for the families in particular, parents, who, if somebody was put into detention at the moment under children's DLA down south, the parents could lose their mobility and their ability then to visit their child in detention. So these are important. That's an important change. It's a minority of families that it affects, but it's an important one for those families.
Thanks, Bill. I think Anne Braddock wanted to come in. Anne, would you like to come in?
I think that the fact that parents and users of services and everything else have been consulted, certainly the parents that we've dealt with and we work with expressed the fact that they felt as if they were contributing to how the benefit was developed, and that it gave them a better insight into how the benefits work. So I think that's something that should be carried forward very much into the adult disability payment, and I think there's a lot can be learned from that. Just the fact that the effect that it has on people who will be applying for the benefit, feeling that they are part of the whole system.
Thank you. Thank you.
Thank you, Carlton. Okay, Jeremy Balfour.
Thank you, Camilla, and good morning to the panel. I wonder if I can ask a question that came out just over a year ago on the cross-party group on disability, and the letter you may have seen previously, and that is in regard to children who have a disability who are on benefit, but the fear is that if they get slightly better, they will then lose that benefit. And there's this kind of catch-22 of how do we make sure people have the right benefit, but at the same time, with certain conditions, hoping the child will improve. And this one maybe not for regulations, but as we go forward to adult ones and as we trial the children's benefit, have you any comment on that? And is there any way that we can devise a system which doesn't discourage children from getting better because they are on that benefit?
Who would like to answer that?
I don't know if Bill wants to start.
Who would want to start?
I don't think any parent with a child with an impairment or a health condition would seek to limit an improvement in their condition or impairment just for the sake of benefits. They really, for so many children, it acts as their impairment acts as a barrier to their social life, to their family life, to their education, etc., so that when improvements are made, either by aids or adaptations or an actual improvement in the condition, I think what you'll find is that most families greet that with absolute joy rather than thinking about the benefits that they might lose. Again, Anne and Ed have direct contact with those families in that situation, so maybe they want to provide some views on this as well.
Thank you. Anne or Ed, would you like to answer that question?
I would definitely agree with what Bill says. I think if parents see an improvement in the child's health, the last thing they're thinking about is how it's going to affect their benefits. So I don't really think that it's something that would affect the way the system would work.
I suppose, can I put it another way? There is a danger that once a child starts to get better, they lose everything, or they can lose the car or whatever. And I suppose what I'm looking at is, do you think there should be a more of a tiering system, that the benefit doesn't just simply disappear quickly, but maybe it should disappear over a number of months, or it should go down maybe in the amount of money that they get over a period of time, so the family don't suffer financially by that. I suppose I'm looking at more from a family perspective, that the child suddenly improves and they are then financially going to be quite a lot worse off. Should there be some kind of tier system where you don't just fall off a cliff edge and lose everything, but it's done over a period of time?
I think that would be a much better way of dealing with it. That would also allow for the establishment of how much their improvement has actually impacted on their need for care, because when something improves, it's difficult to say whether that can be sustained or how it will affect a child over a longer period. So if there was like a sort of stepped move, that would be a much better way of dealing with improvements in condition.
Ed Pipers?
Just briefly, this has been explored a bit by the DACBEG, and I know CPAC have been thinking about this as well. And the idea that you could have a run-on period of benefits, so you make a decision, but you're no longer entitled, but your benefit continues for a period, which gives you time to adjust your finances, but also to be signposted to additional support that you might need, is something that has been, we certainly suggest, and I think DACBEG put it in a potential recommendation for future changes. So I certainly think that there's something that could be done around that for a relatively small cost. It could provide that help for families in that situation, because you're right, Jeremy, but if a child is no longer entitled to a disability benefit, that can have a massive impact on a household's income, which obviously needs addressing in some way.
Okay. I'd like to now call Rachel Hamilton.
Thank you, convener, and morning to the panel. I'm going to cover, just so you know the subject, the transfer from DLA. And the first question I'd like to ask is, do you believe that there are any scope for change or improvement that could be made following the implementation of the CDP pilot in Perth and Kinross, Dundee City and Western Isles and other local authorities in November 2021, when those pilots are then, the examples are then used in other local authorities? And I'll just throw that open do you want to go first, Bill?
Whether there's scope for improvement, I hope that lessons are learned from the pilots that can be used by the Social Security Agency to improve the service it offers to parents and children. I think fundamentally a safe and secure transfer is something that we heard very strongly from our own members, some of whom are parents of disabled children, and it's quite a difficult one. We obviously want improvements in any benefit that's been devolved to try and iron out any difficulties, and as far as possible, to make the claiming process as simple as possible, to do things such as Ed suggested, run-ons, if a condition changes and maybe a temporary improvement or maybe a permanent improvement, to run on the benefits for a wee while longer, just so the family can make an adjustment. But the difficulty with making any large-scale change to the regulations would mean that children would have to be reassessed, and that could be quite a stressful process for the families, because they wouldn't know, when you are assessed again, whether you're going to get an increase in benefits, a decrease in benefits, or lose them altogether. So that's why the families themselves are so much in favour of not a huge amount of change on the transfer. So as I say, I hope there are lessons learned in terms of the rollout of new claims and the transfer of existing claims, to make sure that nobody loses out. But I think there's a limit on what can be done.
Okay, and just to add to that, to bulk out that question, to the other witnesses, do you believe that in the development of this, there was sufficient safeguards against any mistakes made in that transfer process? Perhaps the other witnesses would like to come in on that.
Anne, would you like to start?
Yeah. I think there was as many safeguards put in as could be. I don't think you're ever going to get it where it's going to be absolutely 100%. I think that if they use the pilot as a sort of test for change, and closely report on all the different outcomes, not just from figures, but also the effects that the system has had on families, and make sure that everything is transparent as possible, and consult advisors and parents as to how it's worked and how that can be used in the rollout. I think anything that can safeguard the need for redeterminations has to be considered and has to be part of it.
Yeah, Anne, and thank you for that. And I suppose just to sort of again build the questioning on this, and perhaps Ed wants to come in. During this, was there any discussion about the 13-week eligibility decision time? Was there any discussion about reducing that, for example?
Ed, do you want to come in on this one or add anything you wish?
Sure. In terms of that specific question, I'm not aware of discussion around that. I think what's key is that, as we talked about, the processes around child disability payment are important, and so that the Social Security Scotland take feedback, as Anne was saying, from families around the process in the pilot areas. When the letters went out, did they explain sufficiently what was happening? Is there support available for people? How's the new claims process working? And I understand the programme of building processes that are adaptable, but are agile and can be moved, changed. So it's important that is used during the pilots to improve it for the rollout in the rest of Scotland. I guess there is one concern that we kind of flagged up in our note we put in around the transfer, is what happens if it appears from the notes that Social Security Scotland are relying on data from the DWP as to who should be transferred to Scotland and who should be transferred to the Scottish system. The problem comes if there's people where there's borderline cases. So, for example, you have a child whose parent lives in England and the child lives in Scotland. Will that be picked up in the DWP sweep of addresses? If there's a bit of lack of clarity around where someone is resident, how will someone in that position get themselves into the transfer process if they're not picked up by the DWP data sweep? So that's a question I think that does need to be explored slightly. May not be picked up in the pilot, but it might be something that's picked up as the rollout is brought across Scotland by the end of the year.
Bill Hamilton?
Yes, thank you, convener. Do the witnesses have any opinion on whether people should be able to choose to transfer to CDP, and how should they be prioritised for that transfer? Can I bring you in again, Bill, please?
Yeah. I think it's going to have to be a phased transfer, otherwise you could overwhelm the system. If everybody chose to transfer at once to CDP, for example, I think it would overwhelm Social Security Scotland staff. And to a certain extent, there is no huge benefit in doing so at the moment, because there's very little difference in the regulations between children's DLA and Scottish children's disability payment. So I'm not sure that anybody would be extremely keen to transfer because they think it would be a big improvement in the amount of benefit that they would be receiving. But as I say, there could be individuals, I suppose, that want to do it. But I think a phased transfer is probably preferable, because you can plan on that and make sure again that the last payment from the DWP is followed by one from the Scottish Social Security system, because the last thing you do want is an interruption in those payments, or the file to go missing somewhere, because it's a bit of an anomaly in terms of the system that you've sought transfer before everybody else with your initial of the alphabet or whatever. It just might throw things out a bit.
Okay, do any of the other witnesses want to come in on that? Anne, yeah. And Ed.
A phased transfer would be preferable. Just as Bill was saying, I think like if you try to transfer the rest of the country over right away, I think it would be overwhelming. And a phased transfer also gives you the opportunity, as problems maybe come up, to be able to adapt so that the next change coming on doesn't have the same problems. If you look at the transfer from DLA to PIP and the problems that caused, I think that's kind of a good example of how a transfer has to be very carefully managed and very carefully explained to claimants. When people change from DLA onto PIP, they were invited to apply for PIP, but if they didn't reapply, the benefit was stopped, and you don't want something like that happening with this benefit. So I think it has to be carefully managed, a phased transfer, but also very well promoted to claimants as to exactly what's happening. And I think that would be better if it's staged rather than a national transfer at the one time.
Yeah, on that, Anne, I presume you're mentioning... Sorry.
Did you make that your last question? Thanks.
Yes. I think Ed wanted to come in, but I think Anne was making some of the points that have been highlighted in this committee, which, for example, is the child winter heating payment assistant on the transfer from DLA to PIP, and I presume that these are the types of things that you wouldn't want to see repeated.
Yeah, very much so.
Okay, and before we move on, then before
Ed
we move on, sorry, Rachel.
Ed wanted to come, Nina, but I don't know if you've got.
I'm going to call him. If you give me a second, I was just going to say I wasn't going to take every speaker and every question. So if you do want to, if it's not covered, could you just put an R in the chat box? Otherwise, we'll be quite slow. But Ed, if you want to finish off anything that's not covered, that'd be great. Thanks.
I think Anne and Bill covered it most. Just on priority, it seems that the groups that they're targeting are where there are different rules for the CDP, children turning 16 and terminal illness, and that seems the right approach to take.
Thank you very much. So we're going to move on to theme 3, which is the incorporation of case law, and might have a few questions myself. I'm going to start with Jeremy Balfour.
Thank you, Camina. I mean, I suppose the obvious question is do you think the regulations give enough protection to case law, particularly in regard to definitions of what is nighttime care, and all the case law that's developed over the last 20 years around this? I know there's been some concern in the past that there may be confusion of what case law does apply, and it's just to get the panel view, is this been covered enough within the regulations?
Bill, would you like to start, and then?
Yeah, well, again, Ed really is the technical expert, but I do think in terms of nighttime care there is a problem, because the wording has been changed, and that means any court or tribunal could interpret the new wording differently from the existing wording in children's DLA regulations. So it may actually create a barrier to families receiving the higher rate care for nighttime care because of the new wording, and there is still a worry that case law is not written into the regulations, I don't think. Now, obviously, if guidance to decision makers, to those that are making determinations at the Social Security Agency, say follow existing case law for children's DLA, that should avoid a huge number of cases going to appeal. But there is, because individuals do differ at the end of the day, there will always be a few cases that get through. But where there is a difference in wording, you could find that a tribunal in Edinburgh makes one decision based on the new wording, and another tribunal in Glasgow makes a different decision, and neither of them follow the existing case law for children's DLA, and that would create the sort of problem in the system where it became a postcode lottery as to whether you got the nighttime care element added or not. And I think we want to avoid that as far as possible. So I do wonder why the wording's been changed, because I'm not sure of the reasoning behind that.
Thanks. Ed, you've been the expert on this. Would you like to come in?
Yeah, I mean, I think this is a concern that members have raised throughout the process. I think probably the only real test will be to see what happens once it's rolled out. But they have struck a quite a careful balance between where they can succinctly put case law in the definitions, including it, and where it's not been possible to do that, they have mirrored the language that's used in the DLA regulations, which certainly suggests that tribunals should follow the case law on DLA in the case law on the laws in Scotland. How tribunals will view that, we don't know, but there certainly seems to have been, they've taken on board the points made about case law, and they have struck a balance. Whether that balance is right or not, only time will tell, but it seems to be. But I would echo Bill's point around where they have changed the language that's being used in the legislation, because they haven't changed the language throughout the rest of it, that suggests there might be a difference. And if that's not intended, the question would be, why have they used different language? There are some places where they have deliberately changed the language, for example, around severe behavioural difficulties. The language used for DLA was somewhat regressive. So they've reworded that. So hopefully that is an improvement. But yeah, there's a concern about the definition of frequent attention during the night, which uses a different language, which could be potentially problematic. But I think, as Bill said, what's important is that this is made clear in the guidance that decision makers are expected to be following the rules for DLA. And if the guidance is clear to decision makers and decision makers keep to that guidance, then hopefully these cases can be there won't be the appeals that we've seen in the PIP and DLA system.
Jeremy Balfour?
No, I think that's been helpful. Thank you.
Further to that, could I ask you, Ed, given that's quite a concern, if we thought there would be potentially a variation in the way that the regulations be interpreted, do you think there's any need for guidance, for example, to the tribunals? And I had expressed some concern in previous committees on different subjects that I do think a refresh of the administration and judiciary might be helpful when it comes to social security matters. Just wondered what you thought about that.
Obviously, the tribunal service is independent of the government and the agency, and that's how it must be. And so I think it will be up to tribunals and ultimately be up to tribunal and even the higher courts to make a decision about whether or not the case law that's been built up around reserve benefits applies to devolved benefits or not. Where the guidance is important is that the agency's own staff receive clear guidance as to what they're expected, how they're expected to be making these decisions. And as I say, many of the case law is often quite subtle and so would be hard to put in legislation. And so what they've done is use the exact same language. There would be a presumption on the tribunals, but if the same language has been used for the same purpose, then case law that applies in previously applied across the UK would continue to apply in Scotland. But that's up to the tribunals to decide, I guess. And I don't think the Scottish Government or the agency would be in a position to tell tribunals how they should interpret the law.
But if there's a higher court decision being made, then the tribunal would be required to implement that decision of a higher court. Yeah.
Absolutely, yeah.
Okay, I'm going to move on to theme 4, which is the past presence rules. So an earlier draft of the regulations replicated the DLA rule that a person over the age of 3 must be present in Great Britain for 2 of the previous 3 years. And in your submission on the draft regulations, that has now been altered to reflect the recent court decision. And the final draft of the CDP regulations provides the presence conditions being 26 weeks for children aged 6 months or over and 13 weeks for children under the age of 6 months. Maybe we could start with it. I mean, have you got any concerns about the past presence rules you want to share with the committee? Or are you content?
I think we brought the court case against the UK government, against the DWP, about the 104 weeks rule and won that just before Christmas. And it's great that the Scottish Government have reflected that. I mean, I don't think they had any choice because there could have been a case brought against them had they not. But it's great they reflected it. SCORS as a whole has been considering the past presence test for disability benefits. There is certainly an argument to be made, but it is somewhat unjust. disability living allowance and child disability payment are there because there is an additional cost imposed on disabled people by society, and that additional cost is imposed on you regardless of your immigration status or your time in the UK. And so is it feasible to reduce that test further and more broadly to look at people subject to immigration control? I don't think we have a position fully on that yet. It would be good if the 26-week rule was shortened from a sort of access to benefits point of view, but that has to be weighed up by other considerations. So hopefully this is something that could be explored more fully once the safe and secure transition has been done, and we can start looking at revising or where the rules for child disability payment can be revised.
Ed, what would be the case for reducing it further from the 26 weeks? Could we tell the committee, I mean, if you were, take the point you just want to wait until we embed this, but would there be a case for reducing it further, and what would it be?
So, for example, a family with a disabled child who's been working outside the UK, their job ends and they come back to the UK and they start working here. They're not able to get that help for 6 months until they've been in the UK for that long, even though they've fully moved here and they're fully, they've got no intention of leaving, whether they're UK nationals or some other nationality. There's an argument to say that they should get help as soon as they're here because they'll need that help at that point. They're not getting help from anywhere else.
Thank you very much. I think there's no other questions on that. And we have our convener, Bob, back. Before I hand over to him, I think we'll just move on to theme number 5. I'll call Shirley Robson and I'll hand the chair back over to Bob Joris. Welcome, Bob.
Thanks, Pauline, and thank you for convening. My apologies to the witnesses. I was fighting first with ScotRail and then with technology in terms of logging on, so I've missed the bulk of this evidence session. But I can see that we're now moving on to theme 5. I'm not aware of bids for theme 5 other than what is in the chat box right now, so my apologies if I bring someone in the correct order. I'll say to colleagues, can we open up in theme 5 with Shirley Robson?
Thanks very much, convener. Good morning, everyone on the panel. I want to just ask about whether the regulations provide adequate rights for someone to challenge decisions about their award or to get their ongoing award reviewed. Perhaps start with Bill, maybe.
A difficulty we've talked already about whether a child's condition or impairment improves, but if it deteriorates, I think there should be a right to seek a review of the earlier determination. So if you've got somebody with a mobility issue and it gets worse, and you want to get them on higher mobility, you should be able to go to the agency and say, child's walking ability has deteriorated, and want you to look again at the determination, and in order to get them onto the higher rate. And at the moment, it doesn't see well. What it says is that Scottish ministers can look at the possibility of whether an increase in award would result from a review, and that introduces an element of discretion as to whether a review will actually take place or not. And I think all of us think that a review should take place if it's requested, and except in exceptional circumstances where there's quite obviously been no change. So if you just say, I want a review because I don't agree with how you came to an earlier determination, that's actually an appeal rather than a review. And if it's well outside the time limit, it shouldn't go ahead. But if there has been a genuine change in the condition, then and that's notified to the agency, then a redetermination should occur. Again, Ed or Anne, have you got anything to add on that?
If I could add it.
Of course, yes.
Sorry. As Bill was saying, the ability to ask for a redetermination due to a change of circumstances because of deterioration does actually happen quite frequently. And sometimes it's caused by, as children develop and get older, their conditions can change, and the assessment of those conditions can change quite a lot as an award goes through. So it is really necessary that somebody is allowed to make a request for a redetermination and it goes through. Trying to establish possibilities, whether something possibly might change or could lead to a situation where that's challenged. So you've then you're going through the appeal system to get a decision from a tribunal on whether you can apply to get a change of circumstances, which can then be appealed. So it lengthens the whole process. So it is quite vital that it's set down in regulation and it's very clear, because when you've got a whole lot of different people making different decisions, I think it would end up where there's an awful lot more challenges going forward, just on whether somebody can actually ask for the redetermination.
Ed, do you want to come in?
Sure, yeah. So I think, as Anne and Bill have made that point, there's not a clear, unambiguous right to request a review, which is kind of what we called for. What we do need to see is very clear guidance to decision makers, but anyone who requests, who says there has been a change in their circumstances, that should be accepted and a review happens. It doesn't mean the award will change. It may be the decision is that the award is still correct, but there should certainly be that process, what should be done. I think another area where we feel that there's maybe not an adequate right of challenge is the amount of time you have to ask for a redetermination after the first decision is made. That's been increased from 31 days, but it was, to 42 days, but we still feel that is far less of a right than you have within the UK system, where essentially you can ask for your award to be looked at again at any point in the year after the decision has been issued to you. And whereas in the Scottish system, you're going to have to show good reason. And as Anne said, there's another example of if you put it in and the agency decides you haven't got good reason, then you're going to have to appeal about good reason. It puts another decision-making process in place. So again, we'd call for there be clear guidance to case managers that all but the most unfounded cases are allowed in. There's no point in refusing it, because you'll just have to end up in this cycle of appeals if they're not careful. I guess there's a couple of other things that we kind of flagged up in our submission. The case of missing information, if a decision is made based on the ignorance or mistake about a material fact, in the UK system, the client is allowed to challenge that further down the line. So a typical example would be a child who has multiple conditions, whereas and the agency has only been notified of one condition at the point of claim. 3 years later, the carer takes some advice and they realise they should have told the agency about this other condition. Under DLA, you're allowed to get a new decision on that basis. It would only apply from the date you tell them, obviously, but it would be a new decision. And again, there's no unambiguous right to do that in the Scottish system. It's not a change of circumstances. The child's always had this second condition, and so it relies on the official error provisions. But somehow it was an error that the agency hadn't been told this. Now that might apply, or it might not. We would have preferred to have seen an unambiguous right within the regulations that allowed if there has been a missed bit of information at the claim process, to allow that to be looked at later on. As again, that hasn't been put in the regulations. So again, it needs to be very clear in the guidance to decision makers what they should do if such circumstances arise, and what should happen. As we've kind of said throughout this process, it's always more preferable to have these rights in the regulations, but if rather than guidance, but if they're not in the regulations, they have to at least be very clear in the guidance. And one thing about all of these process issues within child disability payment, is important that information on how it's working is gathered, reviewed, and changes are made if there appears to be a problem with this. So if they're seeing a lot of late requests for redeterminations that are being refused, or if they're seeing people who are requesting changes of circumstances and the new decision isn't being made, that information needs to be collected and acted upon. Now, hopefully there won't be any of those cases, but they should at least be looking out to collect that information. We'll certainly be speaking to our advisors and collecting information, as I'm sure will Bill and Anne and other members of SCORS, but it would be good if the agency was centrally collecting information so we can have real evidence-based discussion about what improvements need to be made. I know the Scottish Government are, and the officials are wanting to make a system that works, and we're all supporting that. There's obviously slightly differences of opinion on how that can be achieved, so it's important to be able to review that further down the line and see where things have worked and where things haven't worked so well.
Jonah, do you want to come back in on that?
No, I think that's clear, convener. Thanks very much for highlighting some of those issues.
Okay, thank you. And Colin, you wanted to come on this theme.
I wanted to ask, trying to get my head around this, I just wanted to read this paragraph out about the right of appeal. So it says here, there is no right of appeal if ministers decide not to make a new determination. This is the bit that I wondered if you could help me with. Although ministers must do so if it's possible that the award would change. If a new determination is made, then the claimant can request a redetermination if they disagree with the result. What my concern was, Ed, is how could ministers make an assessment of whether it's possible that the award would change? I wondered if you could help me with that one.
I guess that's the crux of the issue. The decision maker will be making a decision about whether the change that has been reported could possibly change the award. And if they decide that the change that's been reported couldn't possibly change the award, there's no new determination, so no right of appeal. So, and we see this generally in the DWP system. If you ask them to look at something again, they make a decision, and even if the decision is to do nothing, you can appeal that decision in almost all cases. One situation in the DWP system where that doesn't apply is if you've been refused employment and support allowance, a totally different benefit. If you've been refused that, then you say your condition has deteriorated, so you want another review. There's no way to make the Secretary of State for Work and Pensions carry out that further review. And we know that causes problems in the DWP system. So the danger is that that's what happens with child disability payment. You have exactly that problem. The carer or parent of the child reports that their condition has deteriorated. A decision maker looks at that and says, well, I don't think that is a deterioration in their condition. There's no possible way that could affect the award. Therefore, we're not going to make a new decision. Therefore, there's no right of appeal and nothing happens. And there's no way then for the parent or carer to pursue that further apart from through judicial review or a complaints process. Now, as I say, if there's very clear guidance to decision makers that any request for a determination without application on the grounds of change of circumstances is accepted unless it's absolutely without foundation. So, as Bill says, someone writes and says, the condition hasn't got worse, I just think that decision you made 2 years ago was wrong. Well, that's clearly without foundation. There's no change there, and you can't have a new appeal right on a decision that you've already exhausted that process on. So there's a very few cases, but in practice that doesn't happen. You know, as Bill and Anne know, you don't get families who want to keep challenging the same decision after it's already been made. It's more likely that there's been a deterioration in the condition, and it's And we've got to remember that the DLA components cover a huge range of conditions, and so someone's condition may well have deteriorated, but it wouldn't mean they'll be entitled to a different rate of benefit, but there still has to be a determination done to tell them that, and then they can either accept that or not, and if they don't accept it, they've got the right of going to appeal. But the important thing is that a determination has to be done, and the way the legislation is set up at the moment, the person who decides whether or not a new determination has to be done is the same person who is making that determination, the decision maker or case manager at Social Security Scotland. Does that answer your question?
It does, but just to very quickly just emphasise this word, although ministers must make a determination if it is possible that the award would change, do you think it's arguable that every single case then would be possible if that's the language being used? What does that mean? That
is another, I guess what they've got here is they're trying to balance two things. They're trying to balance the rights of individuals to get awards looked at again, but we don't want a situation where case managers can pull a case at any point and review it, because people need to know once a decision's been made, that decision's been made and will last for the time that's taken. But yeah, the way it's worded, any change that could possibly result could be interpreted far too widely, and anything that's done could result in review. For example, this maybe is more applicable to adults, but certainly children as they get older, if they start doing a part-time job. Now, the Scottish Government's policy is very clear that taking work won't affect your entitlement, but obviously taking a job could possibly be a change that affects your entitlement. So would that then be pulled in under this regulation? Which is why, if this is what the law says, there has to be very clear guidance, but it's clear to decision makers as to if an individual reports a change and wants a review, then the review happens, but they don't use it as a spurious reason to constantly review people's cases when when the agency wants to. So it's getting that balance right, and that now I think it's going to have to be done in the guidance to make sure that's clear.
Thank you very much. Thank you.
Thank you very much, Pauline. We'll go to Keith Brown now.
Thanks, Convener. I've just got a couple of questions in relation to information sharing and the tension between wanting to get as much information about individuals, applicants as possible, and to use that to the maximum effect to maximise benefits that might be payable at the same time as respecting their privacy. So the Information Commissioner's Officer has said that they are content with the proposed regulations, and they draw attention to the importance of transparency and making clients aware of how their data might be shared. I just wonder whether the witnesses have got any comments on the information sharing provisions, and in particular whether they have any concerns about the privacy rights of applicants. Maybe start with Anne.
We certainly do have concerns about the prospect of information sharing to local government. We can see the point of wanting to share information to increase the chances of other follow-on benefits being awarded, but when it comes to things like the Scottish Welfare Fund or disability housing payment, we're a wee bit concerned because these payments are individually assessed, and what we don't want to see is where the information being shared is then used to not award rather than to award, if that makes sense. For example, somebody applying for the discretionary housing payment, saying that they have a disability that affects how they do stuff, and then because they don't have an award of child disability premium, they're refused things like extra, being paid for an extra bedroom, things like that. Also, it would be crucial to make sure that people, when they're applying for the benefit, are given the opportunity to opt out. We would actually prefer to see a system where people opt in so that they could maybe choose that they could share information for council tax purposes, but not for Scottish Welfare Fund or for DHP, which are more open to interpretation. When people are applying for things like the child disability premium and more so the adult disability payment, they look at guidance, but they don't really, they're more concerned with applying for the benefit and how it's going to affect them after it. So I think it would need to be very clear in guidance, the implications of this, to avoid there being cases where people don't want their information passed on and feel that they can't say anything to avoid that.
Keith, do you want to come back in?
Yeah, just say thanks so much, Dan. And I don't know if Bill's got any comment he wants to make, and then Ed.
Yep. There is a willingness amongst disabled people to share relevant information. And I think, as Anne says, it should be about opting in rather than opting out. So, you're clear about the fact that you want to share that information. For example, medical records, at the moment, GPs can charge quite significant sums of money, £120 and upwards, for a letter confirming that somebody... Sorry, lost you. You still hear me, Keith?
It's coming in and out, yeah.
Right, sorry, my screen went blank for a minute there. Sorry. So yeah, the GPs can charge for information at the moment, and it obviously is a far better situation that the person can give permission for the GP to share that information without being charged an exorbitant amount of money for it when they've got very little money to start with. So, that side of things I think is fine, but it is about relevant information, and people sometimes have information in their medical records that they don't want shared or widely. I'm not saying it's going to be. I know it's confidentially shared, but things that are irrelevant to their claim for a disability benefit, you don't want that getting passed over. So it should only be the relevant information to confirm a diagnosis or confirm somebody is missing limbs or whatever, rather than maybe they were sexually assaulted at some period in their life and sought counselling after that. So that isn't the sort of information that needs to be shared with the Social Security Agency unless it's relevant to the claim.
Thanks very much, Bill and Ed.
So yeah, I think I'll just echo what Bill and Anne have said, really. But I guess the key is where they know, but they're not intended to create big government or to extend beyond what is necessary for the delivery of social security in Scotland. The problem is who decides which information in, for example, the medical record is necessary for delivery of social security in Scotland. If it's the GP, that's a huge amount of work for a GP to go through a medical record to decide what is and isn't relevant to a claim. And if it's the agency itself, then they're getting information, and as Bill said, that could include information that's not needed. Also, it's important to remember, from our work, actually, with appeals and claiming disability benefits, it's often the GP or the medical staff often aren't the best people to provide information about someone's care and mobility needs. So as Bill said, it might be very useful for a diagnosis, but the person who's most able to talk about someone's care or mobility needs is their carer, is a third sector organisation that provides respite care, is someone like that who won't be covered by the data sharing agreement. And the danger is the data sharing agreement becomes the de facto default for gathering information, rather than the decision makers looking further afield to where there's other information which may be slightly harder for them to gather because it's not covered by information sharing agreements. but it's more useful for making decisions. So I know I keep sort of mentioning guidance, but this is again very clear to case managers what information they can get from these sort of data sharing, and what information they might not be able to get, and where else they have to go get this information. I think we're all quite supportive of the idea that having some kind of joined up information sharing is useful, and we're supportive of the idea that if the claimant wants them to, the agency will go out and gather this information. But we also know that in many cases it will be much easier for the claimant themselves to speak to their carer or speak to their support provider to get the information and send it in as well, and that has to be equally considered and equally valid as information that's gathered this way. The danger is you get a kind of two-tier of information that the decision maker gets, and they take evidence that's gathered through this way give it more weight than information that's gathered in more informal ways, and we need to make sure that situation's avoided. That's unfortunately what can happen within DLA and PIP decisions at the moment, even though it shouldn't, and so we need to make sure that that's clear to case managers that doesn't happen here. In terms of privacy, that's not really our area of expertise. There may well be concerns there, but I'm not sure that I'm certainly not sure that I'm best placed to answer those.
Well, thanks. I just wonder one final thing, that if the concerns around privacy, confidentiality were satisfied, and the Information Commissioner's Office seem relatively satisfied in that regard, is the other concern the other way, that insufficient sharing of data and information might lead to the potential loss of benefits that would otherwise be payable? Is that a concern for any of the witnesses? Not feel you all have to answer, but anybody that's got a concern around that area?
Yeah, definitely, Keith. That would be a concern. Where information can be shared that's relevant to making a positive determination, we want it shared. And we definitely don't want people losing out. And as I said, to go back to the original point, that disabled people are really upset when GPs charge them for information that they think should be getting supplied to the DWP freely, and this gets round that problem by making the agency responsible for gathering that information rather than the claimant themselves. So that is definitely a step forward for a lot of claimants. Yeah.
Okay, that's fine for me, convener. Thanks very much.
Thanks, Keith. Shona Robinson, I got noticing you might want to come in on this point. Do you still wish to do that?
It was just a slightly different point under this theme, convener, if that's okay, and it's just whether on the consequential regulations, whether there are any other changes to devolved legislation that are needed in order to take account of the child disability payment. Maybe to Bill, firstly.
I'll be honest, Shona, I don't know.
That's fair enough.
It's quite a big task to think of all the areas, and it looks like a comprehensive list to me, but people are paid a lot of money to dig through the various pieces of legislation to find out where it might be applicable or not. It generally is around passport benefits and things like that, but a lot of them are reserved, so it probably is okay. But yeah, there might be things missing that we'll pick up later, and that will be a great pity. But it's very difficult for even for people that are experts in this area of law to pick up all the changes that might be required.
I think that's a very honest answer. Thank you, Bill. That's fine.
Okay, thank you. Our Deputy Convener, Pauline Hill, I know had an interest in the next theme. You want to open up some questions on theme 7, Pauline? Okay, perhaps not at the moment. I didn't spot that Pauline wasn't there. To other well, I see Ed's just put, I don't know if this is our witnesses attempt to filibuster on behalf of our Deputy Convener, but I see Ed's put an R on the. Would you like to come in, Ed?
Just very briefly on the previous question, since we're waiting for Pauline, just to say that we, CPAC have been in discussions with officials at the Scottish Government to try and pick up some issues, and we think broadly they've been covered, but we haven't gone through the consequential amendments regulations with a fine-tooth comb yet, but we will be as we prepare our new handbook, which obviously relies on rules. So I'm happy to report back to the committee if over the next couple of weeks we spot anything that appears to have been missed.
Thank you. Now, I would lead off on theme 7 more generally. I think it's a really good catch-all question. Apologies if this has been crossed over earlier in the witness sessions. I suspect that next week when we have the Cabinet Secretary Committee and we'll look at this instrument, this is a good thing that's happening. We're talking about making it as robust and complete as possible, these regulations. So I've not heard all of the evidence here this morning, and my apologies that I've been unable to do that. But what would the witnesses' priorities be for policy changes once the child disability payment is safely established? So, this is a good thing, this is a progressive thing the Scottish Government's doing. Scores is looking at ways of making it better and more robust. So what changes would you like to see going forward once this is embedded?
Will I go first, or yeah? Certainly, again, I can't speak for Scores as a whole on this one, and I'll maybe let Ed and Anne do that. But in terms of their own members, in the past there've been certainly approaches made to us by parents of learning disabled children who have missed out on mobility component, and I think there could be a few changes in entitlement criteria around about that would benefit those families who find it quite difficult to qualify for higher rate mobility. So that might be a change in entitlement criteria that we would seek going forward. I don't think it would be a huge number of families that were affected, but again, it's one of those where learning difficulties are quite profound, but they just miss out on the entitlement criteria. So on the current ones for children's DLA, so that's probably something we would seek.
Okay, thanks, Bill. Before I bring others in, Pauline, I was just noting there that theme 7 more generally was about once this new payment is embedded, what changes would our witnesses like to see going forward to enhance it further? But I know you had an interest in this particular section, so I don't know if you want to have any additional comments before we go back to our other witnesses for further comments and answers.
You've covered it, so content with that. Thank you very much.
Thank you. Would any other witnesses like to come in and maybe comment on what, once this is embedded, what they would like to see maybe enhanced or changed in the future?
I'll go, Ed. I think going forward, once it has been embedded and we've got a lot more information about how it's working, that to look at tightening up some of the wording, as we discussed earlier, around especially things like the change that's been made to nighttime care, where the wording is now throughout the night rather than the existing DLA definition. So maybe looking at things like that to see how that's been interpreted. So just going over it, and also including users in any reviews that are done to get the best possible information from service users and how it's actually worked. I think that would be a priority, and even to look at getting service users to look at the guidance that's issued to staff. Make sure that it's it's being administered the way it was intended to be. But I think you'll only see that once we've actually got some, cases on, looking at case law, looking at challenges, that sort of thing.
Okay, that's very helpful. Ed, would you like to add anything?
I guess hopefully most of you are aware of the work that SCORS did around the future to disability benefits in general, the paper we published last year, and the key call in that is to have a review of the whole system once we've passed this safe and secure transition place. I know the Cabinet Secretary has announced the intention to review adult disability payment. I think SCORS members would call for that review to be extended to look at the whole disability benefits system and look at what changes can be made. There's many calls for different changes for different from different organisations. I think SCORS's clear call is that this review must be based on the evidence, and that's it'd be important then of the agency gathering the correct evidence during this rollout phase. So as Bill said, there's certain individuals with learning difficulties, children with learning difficulties find it potentially hard to qualify for the mobility component of DLA. What's important is that the agency collects the data on both who is getting child disability payment, but more importantly, who is refused child disability payment, and then that can be looked at and a decision can be made, should child disability payment cover this group of people or not, and that's a discussion to be had around the investment in social security. And another call in the paper is for there to be a sort of human rights budgeting approach view, or at least some way of reviewing the adequacy of disability payments, and that covers both the level of disability payments, the amount people get, but also the scope, who's covered and who isn't, because there will be a line. Some people will fall inside and some people will fall outside, but that decision has to be made based on the evidence that's gathered during the rollout process. As I think I've kind of already indicated, many of the problems with DLA are around process. People find the system hard, they find it difficult to navigate, they find it stressful, and they find it can actually impact on their health and well-being just by claiming, and that shouldn't happen to a social security system. So as well as looking at these sort of things, any review has to look at the processes that are being brought in Scotland. As we've already said, there's an intention in the Scottish Government to do things differently and to abide by these principles in the Act and the Charter. So any review will have to compare how it is actually rolled out with that. That's an important thing. And I think finally, particularly, this is a SCORS position, but particularly CPAG's point is that the devolved benefit system will still interact very closely with the DWP benefit system. And so very careful consideration has to be given to any changes made to the Scottish system, what impact that will have on the reserved system. And we note that, changes haven't been made because of the fear of how that might impact on DWP benefits. And that is a discussion that has to be had. Are we going to continue to mirror the DWP system to make sure there isn't divergence? Or if there is divergence, how's that going to be managed? Because if more children in Scotland become entitled to disability payments due to changes in the rules, that will mean households with low incomes may be entitled to additional premiums within their universal credit or other legacy benefits. So how is that dealt with? Are the Scottish Government able to is that something that the Scottish Government will want to do in the next Parliament? And if so, how will that work in relationship to DWP and the fiscal framework and those bigger questions? So those are kind of things that have to be sorted out before we get to the nitty-gritty of what kind of changes need to be made. There's some kind of big questions to be considered.
That's very helpful. I hadn't thought about, and I think it's called policy spillover, where a Scottish Government decision impacts on reserve entitlements, and if that can be evidenced, then there could be a financial consequence, so that the increase in UK benefits may actually be a cost to the Scottish Government and Parliament. So the committee or our successor committee, I'm sure, will want to unpick some of that and follow that. Can I just ask one final question for clarity then? And just I'm giving my fellow colleagues a note that we're about to end the evidence session in case there's a burning question they feel they need to ask before we do that. But Anne was very helpful in saying that we should use the real life experience of young people and families going through this new Scottish entitlement for child disability assistance and analysed that. She looked in the round to see how we should change it or enhance it or improve it in the future. And Ed was talking about we should look at this in the round, not in isolation. So we should look at child payments and the new adult disability assistance and older people's disability assistance, I would imagine as well, once they're all in, and look not in isolation but all of these new Scottish benefits. So I'm just wondering if we do this in the round, then we're not reviewing child disability assistance as speedily as we could do because they come in on a phased basis. So should we wait till all of them are implemented and have been in existence for a while before we conduct that, or what we, before the Scottish Government or a future committee of this Parliament should review some of that, or should we look for some early lessons for child disability assistance? And I don't know if you want. We're really just talking about timing, I suppose, aren't we?
Yeah.
Yeah.
I see Bill. Yeah. And do you want to comment? And then I think Bill might want to make a comment on that as well. And do you want to?
I think it's too good an opportunity to not take the experiences of the child disability payment into account when reviewing the adult disability payment. Just because of the way it's timed, and certainly if the review is in 2023 for the adult disability payment, you're going to have so much information from the child disability payment that can help. And, you know, certainly it might be a wee while longer, but there's nothing to say that in the interim you can't be checking how the child disability payment works and getting all the information and having the discussions. But I think it needs to be part of going forward, all the disabilities as they come on for the 3 age groups, to take on board what's been learned from the very first one.
It sounds to me as if it's not an either or, it's both, but I just wanted to check that. Bill, then Ed.
Yeah, I really agree with Anne. I think we should learn from every part of the rollout, each of the new benefits, how we can improve it for the subsequent one that's going to be rolled out, because there will be lessons each time. I'm sure that the new agency is learning. Take up, for example, is going to be crucial as well, because it is a new benefit with a new name and a new agency to claim it from. People are going to have to know that and know their rights to apply it, etc. So there will be definitely issues that we can learn from that get put into review of disability benefits. And I do think we need to look across the life course as well. I mean, each of those benefits interacts with the other in terms of when you cross over the boundary between the children's benefit, the adult benefit, and then the one for those who have retired. So I do think we need to look at them in the round in that sense, because some of the I remember the initial consultation that Scottish Government did. They were actually looking at maybe one benefit that lasted a lifetime, and there was no transfer. But you would just stay on whatever it was called, disability assistance. There might be different entitlement criteria at different points in the lifespan, but you could apply when you were a child and still be getting the same benefit when you were 70 or 80. So it does seem to me sensible to look at all three together.
Okay, thanks. And Ed, we'll just take this as a final comment. So you'll have the last word, Ed.
I guess one of the problems that we see with the DWP is their systems allow for changes which may or may not be policy changes that the government the Westminster government would agree to. And we've just done a report, Computer Says No report, where we're told things can't be made to improve the system because the computer won't let us. Very relieved to hear from talking to Scottish Government officials in programme, but they are devising a system that can be agile and can be updated. And so what's important is that ability is utilised and real-time feedback happens. So right from the start, when the pilots start for the transfer from DLA to CDP, that real-time gathering of information about what works and what doesn't work is picked up and put into the amending processes, and if need be, amending legislation where there's gaps, etc. So I think that's important, not only to have that ability, but also to make sure it's utilised, which again comes back to gathering the data about where there are problems and where there aren't problems. And just finally then, I guess, on the lived experience thing, it's important that the experience of the system are feeding into the development of process and what does and doesn't work. And one way to ensure that happens is to have regular training with staff within the agency with people of lived experience. So it's not just case studies, but they can actually meet with people who have lived experience and understand it. And that is key to ensuring they get that direct feedback. And it's also key to building that culture within the agency, but really is a person-centred approach, and that's something I know that DACBEG have previously suggested, and I really hope that can be built into the the ongoing training within the agency, so that people who have experience of the agency are giving that direct feedback to the staff in the agency and building, kind of completing that circle.
Ed, thank you very much. In fact, thank you to all our witnesses this morning for helping us with the evidence session. That does conclude agenda item 2. Indeed, thank you for all your support, given this may be the last appearance in front of this particular committee before the Scottish Parliament's the other side of an election. Thank you for all your support over the years. I know you're regular attenders at committee and your support has been invaluable, so thank you to all of you for that. But we do now end agenda item 2 and move to agenda item 3, which we previously agreed to take in private, and we'll do that on another digital platform. So I'll close the meeting on this platform and I'll see members in the private session shortly. Thank you.